Welcome back. In our spotlight this morning, some inside knowledge for you about what it's like to be one of Sarah Boone's attorneys. You know Sarah Boone, the defendant in the suitcase murder trial. Well, she's on her 9th lawyer right now, and so far, so good. But 3 court-appointed attorneys who used to represent her went before a judge to get paid, telling the court what it was like to represent Sarah Boone.
Like previous counsel, spent an inordinate amount of time with Ms. Boone. I spent over 20 hours during my period of time that I was representing her. I believe that for multiple reasons, the court can find that this case was extraordinary and unusual, and that it would be confiscatory to not pay me the flat fee.
Get this, one attorney even said he had to put up with Boone's gaslighting. How about that? Now, the judge granted payment of $15,000 for each of those attorneys who had not been paid, of course, plus some other fees. So hopefully everyone is receiving the compensation that is owed to them. And I've long said that all of those attorneys deserve a medal for tolerating her. That's just my opinion. And I want to bring in one of those attorneys who should get a medal right now. I want to welcome in attorney Frank Bankowitz. He was number 6 in the order that we've been counting, and we're so pleased to have him here alongside Court TV digital producer Lauren Silver, who's been digging in, researching this case for us, following all of the progression through the years. And we're so happy to dig in with you both this morning. So, Frank, let me start with you. Welcome. Thank you for doing this. And talk to us a little bit, please, about what it was like to represent Sarah Boone.
Well, it was an unusual situation. Case had a lot of publicity, and Miss Boone was very involved with her own defense, and she wanted her attorneys to be also that involved, regardless of what other cases they had. So it was an experience.
Sure. And I know right now her current legal team is saying they're going to present battered spouse syndrome as their defense. And I understand that that was also something that you had intended to present, but there was a problem that Sarah had with it. What was that, Frank?
She did not like the expert witness that we had chosen to assist in that defense, and could not get along with that person. At times refused to communicate, meet with, or do any assistance with the expert that we had retained.
So an issue with an expert. Okay. And we know that her team is also taking issue with something else, with the interrogation that was done. And it was videotaped. We watched it in depth. And apparently they're saying that she was not properly given her warnings pursuant to Miranda versus Arizona. Frank, curious if you agree with that.
She was not giving her warnings necessarily on the video itself, but from my investigation, they had been given prior to the actual starting of the camera. Miss Boone's biggest complaint was the publication of that video by the Sheriff's Department on such things as YouTube, and which has created a very impossible task in picking a jury that would be impartial in the case.
Understood, Frank. And I have a clip from the interrogation. Let's take a look at it together now.
I thought he was okay. Like, I didn't, he's
telling you he's not. He's telling you, Sarah, I can't breathe. He's saying your name, and you're like, that's my name, don't wear it out.
Guys, that's how we are with each other. Like, nobody understands our relationship. The whole suitcase thing never happened before.
Okay, I want to bring in Lauren Silver to accompany you here on Frank for some questions. Now, Lauren, you're digging in. This motion her attorneys have filed. Tell us a little bit about this latest motion and what essentially they're trying to do here, please.
All right, so the motion that they filed to suppress, this is a motion to suppress the full interrogation done by Orange County Sheriff's deputies. This was an extensive interrogation done on February 25th, the day after the death. And they are claiming that the Miranda card, which the deputies physically read off of, was done twice incorrectly. And specifically what they're alleging is that the very last sentence was let off. So that very last sentence is, having these rights in mind, do you wish to talk to us now? The rest of them, you have the right to remain silent. Anything you say can and will be used against you in a court of law. All those things we're used to from watching here on Court TV and also shows like Law and Order. Those were all read properly. It's on video. The question is that last sentence and whether that last sentence not being read is enough to suppress. Her attorney, James Owens, is also claiming that she was coerced in making the statements because when she walked in, deputies told her things like, you have to talk to us. We found some things on the autopsy we need to talk to you about, and creating what he is calling a false sense of urgency that he's terming as coercion.
Ooh, Lauren, this is interesting, and I love that you brought with us your discussion points today, that card, so that we could see that very last line is what defense counsel is taking issue with. So, Frank, back to you on that. Was it legally necessary for these officers to read that line to her?
Yes, it was. They are required to read the entire card, everything that is on the card, and they normally get a piece of paper that is a checklist of what they have instructed or advised against, and they usually have the individual sign that piece of paper. I did not, in my recollection, see that signed waiver card.
Oh, this is interesting. Okay, thank you for that. So this is something big, and Lauren, thank you as well. This is something huge we're going to watch to see if all that footage that we watched on this program is going to be tossed. We'll see. Frank, with respect to Sarah and the interactions, I understand you had her for about 14 months representing her. Did you two get along? Were you able to get along well with her?
That's a tough question. We got along as long as I was there, and we had open access, which at times we did not. But it was a matter of seeing her physically, that she wanted her attorneys, not just me, but all of her attorneys, to be able to be at her disposal. And that's difficult when you have other clients to represent.
Right, most certainly. Yeah, tell us about your job, your career, where you've worked, where you're currently working.
Well, when I first started practicing law, I was an assistant state attorney in the Ninth Judicial Circuit, which is prosecuting Ms. Boone at this time. I was there for about 5 years. I left there to go with a civil law firm in the personal injury area. And I left there about maybe 3 years later and opened my own office. And ever since then, I've been a solo practitioner basically for the last 50 years. I'm a member of the Florida Bar for 50 years.
Well, that's awesome. That's incredibly impressive, Frank. We knew that you knew your stuff, would see you in action. And, this isn't a problem with any of the attorneys that have represented her. Everyone has been so seasoned, so smart. It seems that the common denominator with all the issues is Sarah Boone. And can you tell us quickly why you withdrew?
Well, it was the cumulative effect, so to speak, of the letters that she would send to the judge about he's not doing this and he's not doing that. And all these letters are public record. They're all on the court file. Eventually, it came down to she even wrote a letter to the judge complaining about the judge not doing his job.
Right.
And so, again, these are all on the court file.
We remember that. Yeah, she is a real piece of work. Frank Bankowitz, wonderful having you on the program. We would love to have you back sometime to do some analysis on another case. We won't talk about Sarah Boone. We'll talk about something else. We'd enjoy your time and your expertise. Thank you so much. And big thanks to Court TV digital producer Lauren Silver, all over the story. Check out her great writing on courttv.com.